Welcome back. Prosecutors in the homicide trial of defendant Karen Reed are trying to bar a key defense expert from her retrial because they say that this witness's testimony has been unequivocally debunked. That witness introduced evidence supporting the defense team's theory that Jennifer McCabe Googled how long to die in the cold hours before John O'Keefe was found unresponsive. In a motion last week, prosecutors say that analysis has, quote, been refuted not only by the Commonwealth's independent experts, but by Celebrite itself, that is the software extraction company, saying that McCabe did, in fact, Google this at 6:24 a.m. That is when she said she did, and it was at Karen Reed's direction. So let's take a listen back to some of what came in the trial about this. We have the Celebrite expert, followed by that witness the defense called.
The 6:23 timestamp is when the search was first conducted. Never loaded the page, otherwise there'd be a record in the history database. And while that page was still loading, a secondary search was conducted for Hoss Long to Die in the Cold. Again, that page never loaded either, although these both did show up in the Knowledge C database to show that the browser was trying to display these pages. Safari was closed prior to the Hoss Long to Die in the Cold record being shown on screen at all. But when it was reopened at 10:33, in regards to whatever other Safari activity was to be conducted, it appeared on screen. So we have a 10:33 record where Hoss Long to Die in the Cold was shown on screen, even though the page never successfully loaded.
We found a Google search that happened. First of all, the search was how long to die in cold, and it happened at or before 2:27 a.m.
In what state did you find that artifact?
Yeah, so the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay, so what's more, Celebrite has updated its technology because of this case, because of the defense expert's misinterpretation. And so they've changed the software to make sure that this mistake can never happen again, that someone couldn't mistake the time that a page was open with the time that an actual search was made on the page. Celebrate saying the search happened at 6:24 a.m. when Jennifer McCabe said that it did. So now we have to see what the judge is going to do. Is she going to let that defense expert in to still give that original opinion? Let's bring in the former head of the homicide unit in the Norfolk County District Attorney's Office in Massachusetts, Attorney Rick Grundy. Rick, good morning to you. Reading directly from the Commonwealth's motion here, saying, quote, exclusion is appropriate because these claims lack any evidentiary support and the claims cannot be made in good faith. Allowing introduction of baseless claims without any scientific, forensic, or factual support would be misleading the jury and disruptive to the interest of justice. Do you agree?
Well, I'm probably not close enough to the matter to give you as definitive an answer to that as a judge would. But I can tell you the interesting thing here is that this is not an unusual motion where there's going to be what they call expert testimony. And the big thing about expert testimony is, as opposed to just stating a fact, what you saw, what you heard, you're allowed to give your opinion. So they're filing this under a case called Dauber, which is allowing a judge to stand kind of guarding evidence before it gets to the jury and determining that it is appropriate to go to the jury. So in an expert situation, that this opinion evidence is appropriate to go to a jury. And there's two things they're looking at. One, is this science or other expertise that's going to go to the jury noted and recognizable and accepted within the field as a true science that can produce believable results? And secondarily, is that particular person who's going to offer it to the jury qualified as an expert based on their training, education, and experience? In this situation, it seems that they're attacking both. They're saying that now, as I understand it, Cellbrate is in a position to say, this isn't even good science anymore. But in addition to that, they're saying that this particular witness is not of the qualifications to offer that. Now, there's a part of what I'm hearing that sounds like, well, this is what the classic battle of the experts is. My expert's going to say the new work that Cellbrite did to try and change this result can still be looked under the microscope of how it came up under the old Cellbrite. And that a judge may likely say, I'm going to let the jury hear all of this, and the jury will decide what they want to put their faith in.
Rick, do you think the judge should have a hearing on this ahead of trial?
Absolutely, without question. And I want to tell you something. This is kind of part and parcel of this entire case. This case is a sensational case. And by virtue of a sensational case, I don't mean that it's an overly complex legal case. It's been sensationalized through the media. So this is the court docket in this case. It's 38 pages. Standard case of this nature would be more in the field of maybe 8 to 10 pages. And in going through this, I wanted to see for myself, had there been motions filed previously by either side with respect to their experts to have this standard hearing before this goes to the jury? Judge, let's have a hearing to see, A, is the science correct? B, is this person qualified to offer it? Now, I know that they kind of had a last-minute hearing along these lines with respect to this dog bite person that showed up. But what this docket shows is that these issues, standard pretrial issues, really weren't addressed by either party before the first trial. You go through here, and there's a lot of back and forth, and part of this is sensationalism, but not the legalistic aspects of this case that kind of were dealt with on a last-minute basis in the first trial. You go through there, and there's no Daubert hearings with respect to any of this expertise. And I think that's how it kind of got all over the place. Mm-hmm. So now the prosecutor is trying to, let's do this the right way, let's do this the methodical way, and protect the jury from what might be junk science.
Exactly, Rick. I appreciate you pointing that out. Might we attribute the difference in the fact that we're seeing these hearings now when, as you noted, we should have seen them prior to the first trial, the difference in the prosecutors? Now we have attorney Hank Brennan leading the charge as the special prosecutor.
So, it's interesting. Hank is an interesting choice. He's never prosecuted a homicide before, to the best of my knowledge, but he's a seasoned litigator. And, I always say to folks with respect to this second round, you got to start from the understanding that watching that first trial, clearly the prosecution didn't grab onto and hold on to the reins, which they need to. The prosecutor, this is your case, you've brought it, and you've got to prosecute it with fervor. And that didn't happen. They were always kind of behind the 8 ball. And yet, 2/3 of the jury were convinced that it was, in fact, Miss Reed that struck and caused the death of this individual. So you got to start from that position and then methodically go through. And I think certainly the new counsel, the more experienced counsel, is a part of that, but it's also a lesson learned from that, what I believe was a circus. And the court was part of it. The court's got to tamp down on this. It can't be tried on the courthouse steps.